Welcome to the Unlocking the Club podcast, where we host honest and direct conversations about journeys of access, personal truth, and reclaiming space. We share our truth so that you can find the key to own your truth, honor your journey, and reclaim your space. Grab your keys, your wallet, your phone, and invite your friends to meet you at the club. Here's your host, Angela Taylor.
Welcome to a very, very special series of Unlocking the Club, where we explore one of the most important yet often overlooked conversations that we can have, a conversation about estate planning and elder care. I'm your host, Angela Taylor, and over the past few years, my family, my friends, we've learned the hard way about the critical importance of having a will or a trust in place. When unexpected moments arise, not having a plan can leave families vulnerable. And I've seen firsthand how it can create chaos during already challenging times. Recently, I conducted a poll and the results were startling. 80% of the people that I polled between the ages of 20 and 65 don't have a will or a trust in place. Even more striking is that most of those who do take action, it's only after experiencing a tragic event in their family. National data suggests and supports this as well, with studies showing that a significant majority of adults, particularly between and within the Black and BIPOC communities, have not taken steps to secure their legacies. And when we fail to plan, we leave our families with legal battles, financial burdens, and emotional stress that can take years to untangle. That's why here at Unlocking the Club, we're dedicating an entire 12-part series to unlocking the essentials of estate planning, with bonus episodes focused on adjacent topics. Together with two brilliant minds, Jasmine Young from Young Law Group and Verlena Green-Tuluska from VDG Law Group, we'll break down what you need to know about protecting your assets, building a legacy, and making sure your loved ones are cared for when it matters the most. Our goal in this series is to equip you with the knowledge and the tools to take action now before life forces you to. Whether you're just starting out or navigating the complexities of caring for aging loved ones, these conversations will give you the clarity and the confidence to plan for your future. So grab your notebooks, tune in, and let's unlock this critical conversation together. Welcome to Unlocking the Club's special series on estate planning and elder care. Welcome back to another episode of Unlocking the Club during our special 12-part series on estate planning. I'm your host, Angela Taylor, and excited to talk to you about estate planning pitfalls to avoid. Yes, if you don't do your homework, if you don't work with an expert attorney, things can go awry. And even the best laid plans can go awry if certain common mistakes are made during the estate planning process, or you try to do it on your own, and some of the boxes aren't checked, the I's aren't dotted, the T's aren't crossed. So today we'll highlight the pitfalls that you need to avoid to ensure that your estate plan works smoothly and provides for your loved ones and yourself in the ways that you actually intend. Really excited to be in this conversation today with Jasmine Young of the Young Law Group as we talk about some of those estate planning pitfalls to avoid. And I'm sure, Shane, you have not experienced any of these in your experts service and work with clients, but looking forward to having this conversation with you, Shane, just to talk about like what some of the pitfalls that you may have experienced over the course of your journey. How are you doing today?
I am doing well. Thank you again for having me. And this is actually one of my favorite topics to talk about because I see so many, people fall into these pitfalls, these mistakes, commonly made mistakes. So I'm happy to talk about it and happy to share. But the first pitfall that people typically fall victim to is not planning, right? Just the failure to plan, which we've been talking about throughout the course of this series. For whatever reason, people think, well, I'm not old enough, or I don't have enough money, or, I don't need estate planning, whatever the reason is. the basics are, if you're over 18, you need to have some type of estate plan, because so many things can happen. Accidents happen. Of course, as we get older, illnesses, disability, of course, everyone dies at some point. So when we don't have a plan, we're leaving things to chance. We're leaving it to third parties. We're leaving it to judges, strangers, potentially people that step in and take advantage. So it's really, really important to avoid those dangerous types of situations and plan ahead. So that would be like the first pitfall that we have to overcome. The first challenge that we have to overcome is, just not planning. We need to, be active and proactive in making sure that we have a plan in place.
No, that's really good. I heard another one, a colleague was talking about in their retirement system is shifting from one organization to another organization. And some of the information, particularly around beneficiaries, doesn't transfer over. And so
Yeah.
the system is trying to communicate that you need to make sure that your beneficiaries are updated. But not surprisingly, it's happened in my family as well. When you think that your beneficiaries have been updated, they are not. Is that another common pitfall that you've observed?
Oh, yes, very, very common. And beneficiary designated assets, we see a lot of people trip up on this. So a beneficiary designated asset, or these are things like retirement accounts, IRAs, life insurance. So where you have this asset or money potentially that's going to go to a person or people of your choosing as the beneficiaries, you can designate, those people as the beneficiary of that particular asset. Well, those beneficiary designations actually trump what you have in an estate plan. So people don't realize this oftentimes. So they might put a trust in place, they might put a will in place, and they'll have beneficiaries under that plan. But then they've got these other assets like life insurance and IRA, and they've got separate beneficiaries identified there. And sometimes they do not match up, or, people just presume, oh, well, whatever I have in my will or my trust is what is going to govern. So that's an exception to, kind of the rule, where you have to be very careful, because whoever you've designated on that life insurance policy or on that IRA account is going to receive that money when you pass away. So common mistake that we see oftentimes is, someone's married and they name their spouse, very naturally. They name their spouse as the beneficiary on the policy, the life insurance policy. Well, you get a divorce, you forget to update your beneficiary designations on your life insurance, and your ex-wife or your ex-husband ends up getting that $1 million policy. So common mistakes we see when it comes to beneficiary designated assets, but it also plays into not updating your planning, not reviewing and updating your planning as you should. So another common pitfall is someone or people will put an estate plan in place, and then they won't review it. They won't update it. They, won't, as their life changes, make these really important updates to their plan, and then something happens, and then people that are not intended to receive assets or be involved in decision making, have this really high level of authority. So you really want to be looking at your plan. I recommend at least every year, and working with an estate planning attorney or law firm that's going to provide those ongoing services and an ongoing relationship, and actually assist you. So we've got a VIP membership program at my firm. So anyone that joins, we proactively, as your lawyer, as your law firm, we will reach out and, check in and say, hey, Angela, it's been a year. Happy anniversary. Has anything changed? Oh, yeah. You want to update your beneficiaries? Oh, you got a new car. You sold that property. Great. Let's make sure we update your plan. So, avoiding that common pitfall or mistake of, thinking it's like a one and done type of situation is important. And it also reminds me of my first pro bono case, which was like my introduction to estate planning 20 something years ago. I was a new attorney, And there was a family, unfortunately, that was going through probate. So for those that aren't familiar with probate, probate is basically the court process that your estate has to go through when you pass away and you either have no estate plan or you have a flawed or incomplete plan. So in this situation, I was volunteering my time to help the children of the decedent. So their father had passed away, and they were adults. The children were adults, and they didn't understand why they had to go through probate, because everything their dad said was, I have a trust, everything's taken care of, I did my estate plan. But unfortunately, their father had done his estate plan years prior while he was still married to their stepmother at the time. He worked with a traditional estate planning attorney who basically, had him sign documents. He didn't really understand the ins and outs of how his plan was set up. He never heard from the attorney again. He didn't review his plan. He didn't update his plan. He also didn't fund his assets. So that's another common mistake, another major pitfall that we see that I'll talk about in just a moment. And so when he passed away, unfortunately, his ex-wife, who now they were estranged, of course they weren't together when he passed away, she was still named as a beneficiary on his retirement accounts and his life insurance, which were major assets that he had. And everyone knew that that's not what he intended. Everyone knew that really he would have wanted those funds, that money, to go to his children. But unfortunately, because he didn't make the proper updates, he left the ex-wife as the beneficiary. She received those assets. We were able to help the children get, the other assets through the court process. Unfortunately, it took a long time. But that was kind of my first introduction to estate planning. And I remember thinking, I was this new attorney, first year attorney. I remember thinking like, oh my gosh, how could this happen? How is this not malpractice? Here this client went to an attorney. He paid thousands of dollars, for this trust. He thought everything was taken care of. He told his family, I took care of everything. So he had, unfortunately, this false sense of security. He wasn't advised properly by the attorney, to make sure that everything, all of the bases were covered. He never talked to the attorney again. The attorney never reached out. So as things changed in his life, they weren't reflected in his estate plan. And unfortunately, it landed his family, his children, in probate court. So, it's hard enough when you lose a loved one, but when you are going through that grieving process and having to deal with all of the other things that come along with the loss of a family member, and then you, on top of that, have to go through probate, and which is a public process also. It's not ideal. And there's so many other things that you would rather be doing with your time and your resources at that moment, as really the hardest times of your life. And it can be avoided. So I mentioned also, Angela, the funding process. Mm-hmm. So that's another common pitfall we see, where people will put a plan in place. They'll be like, okay, great. I've got my trust. They sign their documents and they think that everything's taken care of. Well, your assets actually have to be titled in the name of your trust. So if you think of your trust as a box, right? So everything that you own needs to go inside of that box. So if you've got, real estate, bank accounts, investment accounts, life insurance, retirement accounts, all of those assets either need to be retitled or re-registered, or the beneficiaries need to be updated to either be or include the trust. So that's the common mistake we see people make, is they put this trust in place, they sign the documents, but then all of their assets are titled either in their name, or the beneficiaries are not properly designated, and then things end up in probate. So if you have any asset that is titled in your name when you pass away, you're subject to probate.
Mm-hmm. Well, there's so many things that I appreciate you sharing in that story about your pro bono case that is really important for us all to consider. And I'll use some anecdotal stories. When I was in professional sports and sports entertainment, you had these athletes coming out of college who were looking to hire an agent. And we used to always talk to the players about, like, this person is working for you. So you need to take your time for you to screen the candidates to make sure that they are going to do the job that you need them to do. And I think in that first example, sometimes we trust authority figures. We trust our healthcare practitioners. We trust attorneys. And we still need to be the ones that are making sure, right, that that individual, that organization, that firm has our best interests in mind, and that we're following up on certain things. And so I'm glad that you shared that story, is that sometimes, because it's taken many people so long to get to the point where they actually want to do an estate plan, it's like strategic planning in businesses. You take about 6 months to do strategic planning, and then you just put it up on the shelf, and it just becomes dusty and you don't pay attention to it. But this is a living, breathing organism, and you, in conjunction with your attorney, need to make sure that you're constantly paying attention to it and making sure that things are updated, or that you're paying attention to the things that may no longer be factual.
Right. And your estate plan really is supposed to be dynamic, because things change. The laws change, your life changes, your assets change, your relationships change, people die, people are born, there's all these different things, and it's not stagnant. So it's not, it really is not a one and done type of thing, but traditionally that's how the system has been set up. And also because, unfortunately, the reality is that a lot of these attorneys are really just looking to, collect that check to put the estate plan in place, and they don't want to bother with anything after the fact, because, that's not really where the money is, but that's where the important decisions are. And, so you really do want to work with someone that you will have that ongoing access to. You'll have that relationship, so that as your life evolves and your estate plan needs to be dynamic, you're able to make those updates and get guidance. And another pitfall that it makes me think of is, people will look for the cheapest option, or what they deem to be the easiest option. And that kind of is a two-part pitfall. So when it comes to the cost of your estate plan, you really do get what you pay for, and you have to be very careful. If you're calling, even if you're doing research and you ask, okay, well, you call up a law firm and say, well, what does it cost to do an estate plan, or how much does a trust cost? If they tell you a number, if they're like, oh yeah, it'll cost you $2,000, that's a red flag. Because how do they know without actually meeting you and understanding the family and assets and the the relationships, the things that are important to you? How could they know what is going to be involved in your estate plan? So to get quoted a fee, you want to be really careful about that. And then another thing that we see a lot of people doing is, going online, or they're utilizing like LegalZoom or Rocket Lawyer. And those are just form documents. Those are not properly crafted, comprehensive, or customized estate plans. So it's not, estate planning is not cookie cutter. It's not a one size fits all type of thing. And in addition to that, you're not getting the guidance and the counseling that you really need to be able to navigate some of these questions and circumstances that you're not really familiar with. So, I always say, like, please avoid the online estate planning. Be careful about going with the cheapest option, because you really do get what you pay for. And, it's just a shame, because you would think that because you're paying money, you're making this investment, that your plan would be guaranteed to work. And that's just not the case.
Yeah. Well, when we talk about online estate planning, is that better than nothing? And then when you are in position to actually seek legal assistance and advice, can you then take that online plan or documents or templates that you signed, take them to an attorney and have them go through it? Or is it better just to not have anything and start from scratch?
Yeah, great question. And I would say usually it's better to have something versus nothing. But I've seen cases where having certain things causes more problems, because there are contradictions, there are ambiguities, and it just leaves a mess potentially. So Yes, typically it's best to have something, versus nothing. And mainly because you're thinking about things, it actually gets you thinking about certain decisions that you would want made. And then if you do have something in place and, say you've done some planning online, or maybe it's been years, that you put a plan in place, you can take that planning, to another firm, or take it, to a lawyer, or bring it to us, and we'll review it and see, okay, well, here's how your plan works right now. We make recommendations on, okay, what are the goals that you have? Okay, these are the things that we need to do moving forward. So sometimes we can use the planning that you have, or at least use the name, like if you've got a trust set up, and you have assets that are titled in the trust, then we typically like to keep that, that trust, or at least the trust name in place. And we might make recommendations to put new documents or new provisions in place to make sure that the bases are covered. So, just going back to your question, typically it is better to have something versus nothing, but you want to be very careful about how you go about that process, because sometimes gaps can cause, even more heartache and hardship for you and your family, and you don't really want that. My recommendation is just try to go and have the consultation with a lawyer, out the gate, so that you can get, the right information, the right guidance, and so you won't have to go back and redo things, after feeling like, oh, well, I already spent money doing this and now I've got to do this instead. Take advantage of the access and the resources that you have available through this podcast, and also, what we're offering as far as that complimentary planning session, so that we can kind of get down to the details, and then you can make a decision on what type of planning you want, or if you even want planning at all, and what does that look like.
Yes, and Shane and the Young Law Group have been really generous in offering all of our listeners and viewers a free consultation, a $1,250 value. The information is in our show notes. Please take advantage of that opportunity. You will not be disappointed. Shane, we were talking about online planning. And so that brought up to me digital assets. I know we're going to talk about digital assets in another episode, but it feels like there's more attention that we need to pay to our digital assets, whether it's cryptocurrency or our online accounts, or our social media. Like, what happens if someone hasn't accounted for their digital assets in an estate plan? And what are those things that you start to talk to clients about?
Yeah, it's unfortunate, but that's just another trigger for probate. If something is left out, if it's not accounted for, if it's not detailed in your estate plan, then, who's going to make the decisions, right? So it gets left to a judge. And digital assets, as you kind of listed out, many of those things, cryptocurrency, these are all new things, new assets that aren't necessarily titled, or owned, they're not tangible in the same way that certain other assets are. And so they have to be treated differently. One thing that we recommend and that we do for clients is we create what's called a family wealth inventory. And it's essentially an inventory of all of your assets, so that we can identify, track, and title the assets properly from this point moving forward, so that nothing gets left out, or slips through the cracks, that at least we have the information there. And then as far as, access to some of those assets, because we've got like the different codes or different logins or social media, email accounts. Those are things that are really important as far as your digital assets access. So having access as far as the credentials securely saved and available, so that if and when something happens to you, the right person can step in and manage those assets for you. This is of particular importance, I think, for young people, the younger generation. The older generation may not be so into the crypto or even social media, but I know for those younger adults, the thought of their parents, for example, going through their emails or their social media accounts is terrifying to them.
Absolutely.
So, so you want to have those provisions in your estate plan that identify, who would have control, who would manage those assets for you in the event that something happens.
Well, speaking of generations, and this is the question, most of our audience are women of color. And I think, just a couple generations ago, my mother's generation, they didn't have the ability or access to credit.
Mhm.
Sometimes they couldn't have their name on deeds.
Mhm.
And so for them, and oftentimes they're going to outlive their spouse.
Mhm.
What are some of the pitfalls that you've observed for women who may not have their own credit, have their name on some assets that the family may own?
Yeah, and this is, I mean, I love this topic, and I think we'll dive into it when we talk about like the evolution and the changing landscape of estate planning. But
Mhm.
things have changed, So our parents or our ancestors, that have come before us, they lived a different life, and there's been a huge shift when it comes to what needs to be done now. And we're kind of in that interim where we still have a lot, of our like our elder generation that might still be kind of caught in that type of situation where they didn't have any assets, that were titled in their name. But I've seen it happen even, with our generation. Actually, a young wife, young mother. She was in her 30s, and she unexpectedly lost her husband and their home. So they have two young sons. The husband unfortunately died in an accident, and he was the only one on title to their home. And even though they're married, she still had to go through the court process to be able to get access and get ownership to the home that the two of them, both invested in and both, really in reality owned. And so, we see those types of things happening where sometimes, and more frequently, we're seeing our male counterparts that are predeceasing us, and then the women are left to manage. And sometimes, some of these women have never managed the household finances, and they're really at a loss. So that is another reason why, we're here to be able to help and support, because it can be very lonely. It can be very overwhelming. When you lose your partner, in life, you lose your spouse, and not only are you having to go through that process and grieving that loss, but now you're at a loss because you don't know how to access your household finances. You weren't on the deed to your house. You weren't on that bank account. And now you have to go through this other process of trying to figure out, how to actually take ownership of assets that really rightfully belong to you. So it's much harder, as you can imagine, to do it on the back end. And that's why I encourage women, especially, women of color, women in general, to really take the initiative now while, you have the ability to have these conversations with, your spouse, with your partner, and put these things in place for your own protection. Because if you don't, it just makes it that much harder. But what I have seen is a shift where there are a lot more women that are taking the lead as far as planning. And, that is very refreshing, because I think we've kind of seen it happen generation after generation where the women are left to pick up the pieces, and we have to set ourselves up for success. And also, our partners, we want to make sure, if we're in a marriage or if we're in a partnership, that our partner, our spouse, isn't left with a mess to have to deal with. So it's really just out of a matter of love and support for each other that it's important that planning is put in place.
Yeah, 100%. Once, and you've talked a little bit in a previous episode about the benefits of estate planning in Nevada. And
Mhm.
so, are there any pitfalls for those of us that are moving from state to state or country to country that we need to make sure that we pay attention to as we're navigating the estate planning process?
Yeah, so if you live in a state, like if you're in California, for example, you put an estate plan in place while you're there and you move to another state, you will want to make sure that you're reviewing and updating your plan. We go back to that common pitfall or mistake that people make, because each state is a little different as far as certain statutes, certain laws that are in place, and more particularly, it relates to certain documents as far as like the powers of attorney and the healthcare and the financial documents. Those kind of might vary from state to state. If you have a trust, your trust should still work, but there might be updates that need to be made there. So my recommendation is, if you have a plan in place and you are moving, or things are changing in your life, talk to your estate planning attorney. Make sure that you have that ongoing conversation so that they can guide you and make sure that you're properly aligned and making the necessary updates to make sure that everything is current with your plan. So one thing that I will note is, we are based in Nevada. I'm in Las Vegas, but we work with clients all over the states, actually. So that is one of the benefits, or kind of the silver lining for us of the pandemic, is we were able to do everything virtually. And so when we were working with clients here during the pandemic in particularly, and they would say, you know what, I've got my mom that lives in Texas and she really needs her estate plan, but she hasn't met anyone, or she doesn't trust anyone. Now that we're working with you, I'd love for you to work with, my mom as well. So it tends to be kind of a family thing. And of course, each family independently, it's confidential. We don't share information unless you've advised us to. But a lot of times families or extended family members like to be able to work with someone that, their other family members have had a good experience with, and, that they trust. So we are able to work with clients all over the states, and we can do everything from start to finish virtually. So that is kind of a cool thing that we're able to do now, that really wasn't a thing before. But now with technology and also, updates in the law, we're able to do things and have electronic signatures. Nevada was like the first, kind of the trailblazer for being able to have, electronic signatures on things like wills. Before, it had to be a wet signature. So those are just things, different nuances that you want to be aware of. But, if you do have an estate plan, if you're moving, you do want to be working with someone that's going to be able to guide you and support you no matter what changes occur.
No, I love that. So make it a movement, right? Get your family, get everybody together. I know word of mouth is powerful. And so when you have a good experience with an attorney, spread that to others, and so that they can tap into it as well. But get your family, get your girlfriends groups together and say, hey, let's reach out to Young Law Group and get this done by the end of 2024, 2025. And make sure that, again, like everyone's protecting their assets. I guess the last question I have for you, and this is kind of born out of a personal experience, the importance of like having an updated family tree. And this was born out of, grandmother had property in Texas complex,
yes,
with their probate process, etc. And so the certificate of heirship was really important to be able to figure out, but that had been generations ago. And so having to go back and search the family tree and find out who was married, who had been divorced, who had kids, it was time consuming, overwhelming, frustrating at times. And so like, how important is having your family tree in order in the event that maybe you had to go through the probate process?
Yeah, I love that you brought that up, because having to put together a family tree when you're dealing with a court process already is, I can only imagine, how frustrating of a process that could be, especially when, the clock is ticking and, things are costing money and, there's all these different things at play. So I recommend that all clients put together this information during the planning process. So, and more so because most likely they're not going to have to go through probate, right? Because we've done all of the things, as long as all of the things are done properly, we avoid probate, right? Okay. But it's more so on the family legacy part of it that we encourage families to put this information together, because so much gets lost from generation to generation. We don't know our family history. We don't know, the different familial relationships, or how, we got to be where we are and how we're related or connected. So that to me is much more important on the family legacy side, because those are things that you want to pass down from generation to generation. And so like having a family tree, having your family stories recorded, memorialized, your family history. If religion is important to your family, if family traditions are, important, all of these things, these are just priceless things that we want to make sure are properly, memorialized, because it's often things that we don't think about. When we think about estate planning, we're often thinking about the money, the assets, those types of things, which of course are important, but your family legacy is so valuable also. And what a great way to preserve that and pass it on from one generation to the next, through your estate plan.
Love it. Love it. Well, are there any other pitfalls that we should encourage our listeners to avoid?
I think we covered the main ones. I'm trying to think if there's anything else. I mean, of course, the lack of planning is a common pitfall, to kind of recap: lack of planning, failure to review and update your plan, utilizing online planning, or inexpensive, cheap estate plans or estate planning resources. Those are common pitfalls. Failure to fund or title your assets properly is another common pitfall. I think, one thing that I would add is that we often focus on, we kind of look at things in kind of a microscope or isolated, and we overlook things like the family legacy, which we just talked about. So I think, including that would also be important. And just working with a firm that is going to be there, for the long term, not being short-sighted or small-minded when it comes to your estate plan, but really like considering like this is really the beginning of your relationship with your estate planning law firm.
Yeah, no, I think it's really important. And I might add to this list is anytime you're looking for a physician or attorney, it's knowing what your values are. Mm-hmm. It's knowing and making sure that that individual or that organization fits into your values. There's alignment, because when there's not alignment, that can create friction and tension sometimes as well. And so be present in the process of screening and talking to potential folks that you want to work with. Awesome.
Agree.
Really good stuff. Like, I think that the thing that stands out is start planning now and find somebody that's really good about what they do. And we have that person right here, Shane Jasmine Young. Thank you so much again for opening our eyes and providing so much insight and perspective on estate planning, particularly some of the pitfalls that we all can avoid as we're navigating this process.
Yeah, it's my honor. Thank you so much for having me.
Absolutely. Again, make sure you check out the show notes for this episode of Unlocking the Club. Shane and the Young Law Group are offering a really generous opportunity to start your estate plan with a free consultation. Take her up on that opportunity. Let them know that Unlocking the Club sent you. And until next time, I'm Angela Taylor, your host for Unlocking the Club. Thanks for joining us here on this special series about estate planning and elder care. It's really important for us, and hopefully it's resonating with all of you. Until next time, be well.
Thanks for listening to Unlocking the Club. If this conversation resonated with you, subscribe to our podcast on iTunes or your favorite streaming platform so that you can experience every episode. And follow us on social media, where you'll hear about future guests, access special features, and connect with this amazing community. Head on over there and let us know how you are unlocking the club. Until next time, peace.